Alright, Chapter 37 of the National States, Commencement of the National States Requirement to proceed with the repeal of the Publication International Application and Pre-America Inventor Act, Publication International Application Patent Issued International Application Effect, Pre-American Invention Act, Patent Issued International Application Effect and Fees. Title 35 U.S. Code 371 National States Command with the receipt of the international review of the copy to the international application amendment with the claim with the international such report with the international preliminary examination reports to include with the annex thereto with the required with the international application designated with the electing of the United States. Be subject to subsection F of the application national state shall commence with the expiration applicable to the limited time limit under Article 22, 1 or 2 of the Article 31, 9, 1A with the treaty of the application for the patent trademark with a national fee under Section 41A. Copy of the international application will live with required in subsection A of the section already communicated the international review of the translated English language international application if the was filed with another language. Amendments any of the claim international application 19, the treaty of the 5th Amendment to communicate with the patent trademark over the International Bureau of the Translation English language. Such amendments were made in another language over the declaration of the inventor or other persons authorized in Chapter 11 complying with requirements of Section 115 with the regulation prescribed by the oath of the declaration applicable for the translation language of the annex of the international preliminary examination report to its annex were made with another language requirement of respect with the national fee required in subsection C1 of translation referred in Section C2 oath and declaration referred to in Section C4 of the section complied with the date of the commencement of the national states just related with the may be defective with the director of the copy of the international application related with the subsection C that is submitted with the date of commencement of the national states failure to comply with the requirements shall be regarded with the ban of the application parties thereof the payment of surcharge required with the condition accepting the national fee referred to in Section C1 of the oath of declaration referred in Section C4 of the section with the requirements that are not met with the date commencement of the national state with the requirements subsection C3 section complied with the date of the commencement of the national state failure with the total shall be regarded with the cancellation amendments to the claim in the international application made under Article 19 treaty with the requirements Section C5 shall be complied with the times fixed for the director failure to do so with regard to the cancellation amendment to Article 34.2b of the treaty. After international applications have entered the national states, no patent may be granted or refused thereon before an expiration applicable time limit at Article 28 or Article 41 treaty except for the express consent of the application present amendments, specification, claim, drawings of applications after the national states is commenced. If there were express requests for the applicant the national state process commenced for the time in which the application order for the purpose of applicable requirements subsection C of the section have complied with. Title 35 U.S. Code 372 of the National State Requirement and proceed with all questions substance for the scope of the requirements treaty regulations preceding the international application designated in the United States shall be determined in the case national application require regular file with the Patent and Trademark Office. In the case international applications designated for origination of the United States, the director may be called to re-examine the question relating to the coup. Form contents application according with the requirements of the treaty and regulation. Director may call to the question of the unity invention re-examine in Section 121 of the scope of the requirements of the treaty regulation. Director may require verification, translation, international application, any other document pertaining to application of the document filed with language of the English. Title 35 U.S. Standard Code 373 repealed. Title 35 U.S. Standard Code 374 publication international application under the treaty finding of the 351 international application designated in the United States shall be deemed publication under Section 122B except for the provided in Section 154D. Title 35 U.S. Standard Code Pre-American Inventor Act publication international application under treaty under Section defined in Section 351A of the international application designated in the United States shall be deemed publication in Section 122B except for the provided in Section 102E and 154D. Title 35 U.S. Standard Code 375 Patent Issue for the International Application Effect for the patent may be issued for the director based on the international application designated with the United States with the accordance with the provision of the title such patent may have force effect with the issue of the national application filed by the provision of Chapter 11 wherever the incorrect translation scope of the patent granted with the international application designated with the United States with the originally filed with the English language subscope of the international application for the original language court competent jurisdiction may be the retroactively limited scope of the patent declaring unenforceable to the extent of the exceed of the scope of the international application within the original language. Title 35 U.S. Standard Code 375 patent issue for the international application effect for the patent made for the director based on the international application designated in the United States according with the provision of the title section 102E. Such patent shall have the force and effect for the patent issue for the national application filed with the provision of Chapter 11. Due to the incorrect translation scope of the patent granted with the international application designated with the United States scope of the originally filed with the English language except for the scope of the international application for the original language. Court of the competent jurisdiction may, with the retroactive limit scope of the patent, declaring it unenforceable to an extent that would exceed the scope of the international application original language. 355, Title 35 U.S. Standard Code 376. The required payment of the international fee, handling fee, for the amount of regulations paid with the United States currency paid in a trademark current office, such as the national fee defined, provided in Section 3041A, with the charge of the following fee: transmittal fee 361D, search fee 361D, supplemental search fee to be paid when the required preliminary examination for the additional fee, Section 362B, such other fees established for the directors. The amount of fees specified in subsection A of the section, except for the international fee and handling fees prescribed by the director, and may be defined and such are paid in mistake with excess of the fees specified the required in treaty regulation. Director may refund any party search fee, the national fee for the preliminary examination fees, additional fee for the determination of such fund are warranted. Part 5 of the Hague Agreement concerning international registration and industrial designs. Chapter 38, International Design Applications.